Hello and welcome to the big picture. In a landmark move, both houses of parliament passed a constitution amendment bill and also a separate bill to replace the present collegium system of appointment of judges and replaced it with a Judicial Appointments Commission. The two bills which were passed in Lok Sabha yesterday were passed in the Raj Sabha today. However, the Judicial Appointments Bill can become an act only after 50% of the states ratify the Constitutional Amendment Bill and then is signed by the President, which may take up to 6 months. Meanwhile, doubts are already being expressed, including during the discussions in the Parliament, about this legislation passing judicial scrutiny. However, there has been unanimity almost among the parliamentarians that the existing collegium system has failed. However, significantly, the Chief Justice of India has strongly come out against replacing the collegium system. Now that the Parliament has ignored the opposition to it and passed the bill, how will it impact the judiciary? Will it result in improvement in the caliber of judges and the overall improvement in the quality of justice delivery system? We will discuss all this today with Justice Santosh Hegde, retired judge of the Supreme Court, on the phone line from Bangalore, K.N. Bhat, former Additional Solicitor General of India and a senior Supreme Court advocate, Dr. C. Rajkumar, Vice Chancellor, O.P. Jindal Global University, and Maneesh Chhibber, Senior Editor, Legal Affairs, Indian Express. Welcome to all of you. Justice Hegde, I would like to come to you first. Are you happy with this, with what has happened today? Are you happy with the replacement of the collegium system by this Judicial Appointments Commission?
Certainly not. I'm not at all happy with the change at all. Main reason is, if you want to choose a person for a post like that of a superior court judge, like the High Court judge or the Supreme Court judge, the selecting people must have first-hand information about the capacity of the person, his background, and all other information, which can be available to a person who has actually seen the performance of these lawyers before the High Court or the Supreme Court. Now, the commission that they have constituted consists, of course, of 3 judges, including the Chief Justice, then the Law Minister, and 2 eminent persons, could be a lady, could be a backward class person, could be anybody for that matter. None of these people, 3 of them, would ever have any information about the capacity of the person, first-hand information. They will not have it. Now, we are going back to the system which was there in existence prior to the 9 judges case. And of course, I understand there have been failures on the part of the Collegium in making appointments. There have been considerations other than merit. But this is not an institutional fault. This is human error, which will be there even in the commission, that proposed commission, because there are 6 people there, as against 5 people in the Supreme Court and 3 in the High Courts. If you can't avoid human error in Collegium, I'm not very sure whether you can avoid human error in these commissions. Therefore, I'm certainly not happy. I think that you can appoint a commission to inquire into the conduct of judges. The present system of impeachment has failed. Therefore, there should be a permanent commission to look into the conduct of sitting judges, both at the level of High Court and the Supreme Court, and give them the power to remove these judges rather than the impeachment power. Of course, necessary safeguards should be. If you can trust a judge, sorry.
Justice Hegde, that is an issue of judicial accountability. That is a separate issue. But on this particular thing, the argument against the collegium system is that there is no other country, no other democratic country in the world which gives powers to the judges to appoint themselves, and therefore this is not a system which should have been there at all in the first place. Executive needs to have a role in the appointment of judges.
Well, I certainly don't agree with that, merely because other countries don't have a system, that we shouldn't have a system which is more practical. Would you agree with me that a person who is in the commission, who is going to select a person for a judgeship, should have first-hand knowledge about the performance of this judge? If you agree with me, then I'm sure none of these members, except the 3 judges, will have that first-hand information.
They will be able to share. Justice Hegde, the argument is that they will be able to share it with the other members of the commission about their whatever first-hand knowledge they have. So, what is the problem with that?
The problem is that a person who's sharing knowledge from somebody else doesn't have personal information. He is getting it from a hearsay source. What is wrong in having 5 judges then?
Okay, so your contention is that whatever problems has been there with the collegium system has only been a human problem and not a systemic problem.
Certainly,
Okay.
that is.
Okay, sir, please stay on with us. I'll come back to you.
No, I have a commitment. I have told people in the beginning itself that
if you
I
can,
will.
sir, if you can stay on for 5 more minutes, I'll
Oh,
come
yeah,
back.
5 more minutes, I have no problem. Go
Okay.
ahead.
Mr. Bhat, coming to you, would you agree with Justice Hegde that the collegium system has only been whatever failures have been in that system have been human failures? There is no systemic problem with that.
You see, all of you are treating the collegium system as though there was a period of plague or cholera, etc.
Not us.
Collegium saved this country's judiciary. I tell you, Collegium saved the judiciary of this country. You know, the birth of the Collegium was in 1963 when the country was passing through fears of executive excesses and the emergencies excesses were still fresh in the mind.
1993.
So to prevent it,
1993.
under the steward, 1993.
Right.
1993, Justice J.S. Verma,
Right.
he took the stewardship and somehow devised this system as a stopgap arrangement. It was not intended to be a permanent one. And Justice Verma himself repeatedly told that this is not a permanent solution. You devise something better, but what has been devised is certainly not something better. There I agree with Justice Hegde fully that what has been devised is not something better. It is a change, that's all, because and the hurry with which it has been taken through, and I am really surprised that when you want to replace a system which has been working for 22 years, and mind you, judiciary is still the most trusted organization in the country. And this has been possible because the collegium, somehow whatever the appointment they made, did not destroy the institution. It could have been better, no doubt about it, but then this is not the answer to say that this has to be replaced by something else. And then I am not going to the nitty-gritties of this particular act, this one. There are many loopholes and many practical difficulties which you cannot, for example, 5 people of the collegium have to agree on any appointment. Is one at any time 2 members oppose it, your whole appointment process fails. And I don't think that you could have made it as 4-2 or something reasonable. And then there is a process of appointment of a Chief Justice, which is less said is the better. I don't want to take you to the technicality, but long and short I am telling is that this particular system which has been brought in is not going to be better than the collegium. The collegium could have been worked better with a better support.
Well, Mr. Bhat, and
Yes.
Mr. Bhat, the argument which we heard in the Parliament in the last 2 days during the discussions on these 2 bills were that for 22 years judiciary had primacy as far as the appointments of the judges were concerned. Before that, the executive had the primacy. Now this is a fine balance between the two.
It is not a fine balance between the two. It is again going back to the old system by a back door. This is, I am telling you, after reading the bill very closely, I think that whoever is in power has got a habit of thinking that they will be there in power forever. Because you have to examine these bills and the provisions, considering that if somebody else comes to power, what is going to happen? Absolutely. And I don't want in your very precious time which is available here, for example, this new commission does not have a secretariat or a registry of its own. Right. It has to depend upon entirely on the law ministry's good officers. That means, the Supreme Court is working better because it has got an autonomous registry. This commission does not have an autonomous body. Public Service Commission has an autonomous secretariat of its own.
Right.
But this commission does not have.
Okay.
This will depend upon the law secretary will be the ex officio.
Right, sir. We'll come back to you.
Yes, please.
I'll go to, before I go to the other two guests in the studio, let me go back to Justice Hegde so that he needs to go. Justice Hegde, there is one more argument that if only this commission is more broad based, if there are more members in this commission, maybe it will be a better body. Would you agree with that?
Well, if you are going to increase the number in the guise of broad-basing a commission, my main grievance will remain there because those should be people from the judicial institution who know the people who are being considered for appointment as judges of the High Court or the Supreme Court. My main grievance is that.
So you
as
don't,
you said, sorry.
sorry. So you are saying that the executive should not have any hand in the appointment of judges.
Certainly not, because the independence of judiciary lies there. Of course, shortcomings are there, those shortcomings can be rectified, like transparency. There should be a direction given to the Collegium that the names of the people they are considering for judgeship should be made public, so that the public, if they have any input to be given, they can give it. But why this totally new commission, where only 3 judges and 3 outsiders, and two members are giving the power of veto?
That veto part, we will discuss about that, sir. What about the claim of the law minister in the House and many other members also saying that a balance has been struck now. Only judicial primacy was there earlier, only executive primacy was there. A balance has been struck now.
I don't agree with this. That means should there be a commission to appoint ministers with the 2 judges in it and 2 eminent persons also? You got to trust some institution to do their job. Failures, you have to rectify the failures. By bringing in total outsiders and diluting the judicial selection process is very, very unfair, and that is not that's not what is contemplated in independence of judiciary.
So, do you think that this law will be that this law which has been passed, this bill which has been passed, will have to go through judicial scrutiny? And do you expect some kind of a confrontation between the judiciary and the legislature?
No, it is too premature for me. Definitely, as I could see from the public reaction, some of them are contemplating to move the Supreme Court on that, but I don't want to comment on that. But I would end my comments by merely saying that by having law minister, by having 2 so-called eminent persons in this thing, you will bring pressure on the Collegium or the Commission to appoint somebody of their liking, because there are 3 of them there, and 2 can throw out their names and all. So certainly it will never ever work.
Okay, sir. I thank you very much for joining us.
Yeah,
and
I'm
being
sorry,
with us.
I would have loved to continue with the discussion because there were many more things I would have wanted to say.
This debate is not going to end today. We will
certainly won't end.
We'll certainly have you.
Though the bill has put the Collegium in the burial ground, this debate will continue, I'm sure.
Okay, sir. Thank you very much for joining us.
Thank you very much.
Dr. Rajkumar, how would you look at this? That will it improve the overall judiciary, the caliber of people who are going to come into the judiciary? This is one of the arguments.
Well, you see,
and that executive needs to have a role. We can't have judges appointing their own judges.
Well, I mean, predicting such things are always difficult in the course of law because life of law is experience and not necessarily logic. So we'll have to see how it works. But I'm what I am hearing from both the judge as well as the lawyer who spoke is that the entire process in which we have ended up passing a constitutional amendment and moving a legislation for such an important aspect which is fundamentally altering the way judicial appointments are being undertaken, and being fully conscious that the 2 systems that we had followed from independence, one was the primacy of the executive and second was the primacy of the judiciary, and then to suddenly create a new framework, I thought was rather immature and not reflecting the larger framework of how institutions ought to be created. So from that standpoint, it's really not done well. Secondly, all the points that are being mentioned with regard to the problem of collegium, I for one very strongly believe, and I know many judges of the existing Supreme Court as well as High Courts and retired ones, they are also critical of the existing collegium system. There is no doubt about the fact that the collegium system was not transparent. There were many appointments which ought to have been made, which was not made because of personal prejudices and biases of the members who are being part of the collegium. There were people who should not have been judges.
Nepotism is one of the major charges.
Absolutely, and there is no denial in that. But the point is, if we were to create a system which is going to be an improvement from the existing system, then you need to address the problems that the existing system. I believe that the legislation does not at all address. Rather, it complicates the matters further. And I would
How would you say, why would you say it complicates further?
As a starter, the idea of having, the judiciary is a very unique institution. It is not like any other institution where sitting judges are involved in deliberations with politicians and law minister and other people about these matters. There is a certain degree of sanctity and some sort of societal indifference associated with the very functioning of judiciary as an institution. Judges have a different framework of code of conduct when they have to engage and interact with private individuals. Now you are suddenly putting the judiciary into a context where they're going to deliberate about appointments on matters which are very critical, and one
you're saying that sitting with the executive,
deliberating, agreeing and disagreeing, they are vulnerable. And secondly, it's also a very big mistake to start assuming 40 years back we used to do this and we got the greatest judges. Let us recognize that the character of Indian polity, Indian democracy has dramatically changed. The role of governmental exercise of powers today is very different from what it used to be. Government is the largest litigant today. Exactly. Today, the judiciary is scrutinizing so many aspects of governmental exercise of power, and you are putting the judiciary as an institution in a very vulnerable context in which you are at one level in the daytime, you are questioning the actions of the Prime Minister, the Council of Ministers, the Law Minister and many others, and then you have to sit in these committees and actually evolve consensus on candidates. I mean, how much independent anybody could exercise their own.
I think you have a very important point there. Maneesh, one of the things which was said today when the bill was passed yesterday in Lok Sabha, there was this veto provision which has been and that unanimity thing has been removed. You think that makes any difference?
No, it's basically, it's stupid. That is the word that comes to mind, because, right now today what has happened, and yesterday also when the bill was passed.
Before that, tell me why was there such urgency in getting this bill passed according to you?
For that, you'll have to go to the government. But I think, basically, this bill, there has been this talk ever since 93, second judge's case. Successive governments have been trying to, I would use the word, though it's very strong, browbeat the judiciary into submission. So this was their way of, replacing the collegium system. There was always this talk. But
so it is not a question of the specific government in power right now.
All politicians.
It is the political class, the government, the political class were not.
It's a massive gang up against the Indian judiciary, the only organ under the constitution which has a semblance of self-respect and in which people still have some faith. So it's a massive gang up. Till 2 days ago, the Congress was opposing this bill. Yesterday they voted in favor, today they voted in favor. And, they even chose not to move any amendments.
Right.
So, how bad is that? So, it's a massive gang up. And I've been covering politics, I've been covering the ministries, I've covered law, but I don't understand what was the urgency for something which is, everything is not perfect. After all, judges are also human beings. They are prone to make mistakes. But you don't kill a person just because one of his fingers is not doing its job properly. Collegium system, obviously it has its pitfalls. The problems are there. But government should ask itself, successive governments, they have done nothing to improve the system. Actually, there is no system in the collegium system. It's a system without a system. There's no transparency. But did any government do anything to ensure that there was some transparency? For example, if the judges, if the Collegium did not want to make the lists public, so the government could, there was nothing to stop the governments from doing that. They never did that. What instead they were doing all these years was, through selected leaks, some of which came my way also, they were giving judicial, they were trying to create an atmosphere in which they could rush through this kind of system. But even this system, it has no transparency. There is no system now also. The same judges who will sit in court, where is the time? They don't have the time.
I think that aspect has been flagged by several people, Mr. Bhat. This is one of the aspects which is being talked about, that there is a member, that there are 6 members, all of them are virtually, except the 2 eminent people who are going to be on the panel, who also may be very busy jurists or even academics, whatever. Whether the 6-member commission, which is not a full-time commission, can do its job with speed, because as I was just going through the statistics, there are 257 vacancies which are there in the various high courts in India, and there are 900, more than 900 judges have to be appointed. Are there a sanctioned strength of over 900 judges, and they have to be periodically, you have to keep filling the vacancies. With this kind of a commission, will they be able to do it? Because one of the biggest problems now, even today, the Collegium system has also faced this criticism that they don't fill up the vacancies in time.
Actually, Girish, as your colleague Maneesh has just mentioned, no support was given to the Collegium by anybody. The Collegium was treated like an illegitimate child. Nobody ever gave it any support. For example, I'll tell you, whether this commission or the Collegium, there must be a permanent body who will be constantly screening and keeping the required data ready. These people, high-powered, the judges or whoever it is, that they will be picking up from them and doing it. They will not be allowed, they will not be able to, they will not have the time to scrutinize the record of individuals, etc. There must be an infrastructure, and all those things have not been taken into consideration by the present effort to bring in a substitute. So you can, a change is there, but then a change is, it is not for the better, because any system, whether it is either the Collegium system or the new system, there must be a permanent body, experts in management and the like, because then I don't want to go into the details, who will be constantly keeping a data bank ready to be appointed whenever their vacancies arise, because these vacancies don't arise suddenly, because you know the date of birth and the date of retirement of every judge.
Yes.
So you know when the vacancy is going to happen. But then the machinery is not ready to supply the required one for the people, because the 3 judges or 5 judges, they will be picking up the right ones among the available people. But today there is no such concept at all, because you may say that, look, all those things will be done by the ministry of, then again going back to the old system, because if this is not part of the constitution, for example, Public Service Commission has got enough autonomy, but this commission does not have that. So that is my main complaint, is that anything you want to do cannot be done under the present setup and the whatever has been envisaged.
Okay, another issue, quickly I want you to address. This was discussed very in detail in the Rajya Sabha also yesterday, about the legislative competence of bringing in the Judicial Appointment Commission bill, when the constitutional amendment bill is not passed, and unless it becomes an act, you can't have this. There was a lot of discussion on that. You think that this is a problem which could engage the Supreme Court? Somebody could go to the Supreme Court and question this?
Even somebody like Mr. Nariman openly told that there are many flaws in this present decision which he would like to challenge before the Supreme Court. I saw him in the television today, and he's speaking, expressing his dissatisfaction. And I don't want to give any opinion on any particular aspect, but there are many, whenever you do something in a hurry, because the matter was done in such a hurry that when the repeatedly it is said that several jurists have been consulted. I know about that meeting called by the law minister. A copy of the bill was not given to them for discussion. I asked each one of them that did you have a copy of the bill on which you could discuss? And they said no, it was a general discussion. We want to change the collegium system and bring in a sort of a commission, etc., etc.
Okay.
It is neither here nor there unless you give the copy of the bill.
Okay.
So it is the same thing, and so chances of it being challenged are very bright.
Okay.
On what ground, I can't say.
And
Okay.
if I
Yes,
can
yes,
just
Maneesh.
add to this, at that meeting of the, the jurists and everybody was there, senior advocates, academics were there. The government assured them that this is just the first meeting. We'll come back to you with a draft and we'll share it with you. Then we'll also talk to other stakeholders. By that, I think they were referring to the judiciary. And then we'll incorporate whatever suggestions you have into that draft and then, go to the cabinet. But look at what the government did. It talked to people like Falli, Soli Sarabji, former chief justices were there in that meeting, and it slyly goes behind their backs, gets a cabinet approval, and these people, they have been taken for a royal ride. This is not how you are talking about the best institution in this country, and such a, I would say, the flippant manner in which you have dealt with this.
Very quickly, Dr. Rajkumar, you think that there is something in this bill which could improve the conditions of the judiciary, or you think that there needs to be a complete relook at the whole thing? Now that the bill has been passed, it's an of course the constitutional amendment bill has to go to the states, and it takes time. Maybe in this process, you think there needs to be a relook?
I personally think that there is a relook, but also I'm very skeptical of this doing anything good for the simple reason that the so-called broad-based nature of the commission is completely undermined. So, for example, who is one of the most important constituencies besides the judiciary who ought to be represented? Obviously the lawyers. And where are the lawyers? I mean, what is the role of... I cannot think of...
Those two eminent people will be...
Well, we don't know. We don't know. They could be. And we know we have enough evidence in this country that eminence, or the so-called eminence, when it comes to sitting in all these committees, they are not necessarily eminent people. This gives leeway for government to appoint pretty much anybody. And why are we also not discussing that if this usurping of a power by another set of people will somehow change it? Is that our experience? Let's talk about all the different committees where these people have, regardless of whichever governments have been in power in the past, there have been committees which are headed by the Prime Minister, the Speaker of Lok Sabha, Home Minister, Leader of Opposition, and such appointments process have not only been challenged, some of them have been determined to have undermined institutional integrity and revoked under the constitution itself.
Okay, I think on that note we need to end. But the fact of the matter is that it is disturbing that there is so much of opposition and to a bill which has been passed by both houses of parliament. We'll have to wait and watch how this will all play out in the coming days and weeks and months. But the fact of the matter is that there is quite a lot of differences about what has been passed in both houses of the parliament. But as they say, the parliament is supreme. But whether the parliament will have a relook at it, it may be a little too late now. We'll have to wait and watch how it will play out. Thanks to all my guests, Mr. K.N. Bhat, Justice Santosh Hegde, who had joined us earlier, Dr. Rajkumar and Maneesh Chhibber. Please keep watching. We'll come back with another issue on the big picture, same time on Monday.